Greetings, ladies and gentlemen. So, today we shift our attention to another vitiating factor called duress. So, we are going to look at the meaning of duress, we are going to look at the requirements, and then ultimately we are going to look at economic duress. So, what is duress? According to Black Law Dictionary, duress is a wrongful threat or pressure used to force someone to agree to a contract. So duress simply happens when a person is forced or threatened into entering a contract without their free will. So that the person applying pressure is called a duresser. And a good example of duress is threatening someone with violence so they sign an agreement that actually amounts to duress. Now, what is the effect of duress? You see, a contract made under duress is voidable at the option of the innocent party. And that means the innocent party can cancel it. It means the innocent party can avoid it. Now, originally, under common law, duress only included a few things. It included actual violence, it included imprisonment, it included threats to life or physical injury. It did not include threats to property or money. But in this age and time, the law of duress has expanded so that any wrongful threat that removes free choice amounts to duress. Now, remember we have said that the effect of duress is that it makes a contract voidable at the option of the innocent party. And that means the innocent party can cancel it or the innocent party can avoid it. Now, for duress to exist, the innocent party must prove a number of things. The first thing the innocent party must prove is that there was a threat causing fear, a threat causing injury, or a threat causing loss of life. The second thing that the party must prove is that the threat targeted the person or it targeted close family. The third thing that the innocent party must prove is that the threat was illegal. The fourth thing that the innocent party must prove is that the threat removed freedom of choice. Now, there is an important rule that we must remember, and that rule is that a threat to enforce legal rights is not duress. And a good example is if you threaten to sue someone for a real debt or to recover payment, usually that is not duress. Usually that is legal, it is lawful. If you look at the case of Hassan Ali Isa versus Gerard Produce Shop, the facts of this case were that the plaintiff repaired and stored the defendant's motorcycle. Now, the defendant issued a check after the plaintiff threatened to sue him if payment was not made. And later the defendant claimed that the check was issued under duress. And the issue in this case was, did threatening to sue for unpaid repair charges amount to duress? And the rule is that a threat to enforce a legal right does not amount to duress. So that duress only exists where there is illegal pressure removing free consent. The application of this case was that the garage owner only threatened to take legal action to recover repair and storage charges. This was a lawful action because he had a legal right to recover payment. Therefore, the threat was legitimate. Now, the conclusion of this particular case is that the court held that there was no duress, so that the check remained valid. Now, I want us to shift our attention very quickly to economic duress. Now, it's interesting to note that economic duress happens when someone is forced into a contract through serious financial pressure. And a good example is when you threaten to destroy someone's business unless they sign a contract. However, it's important for us to remember that not all financial pressure amounts to duress. The pressure must have the capacity to remove free will or freedom of choice completely. We have here the case of Armsnet Enterprises Limited and others versus Susan Wanjiru Wangendo, which is a 2021 case. And the facts of this particular case were that the respondent bought two plots from the first appellant. Now, she paid the full purchase price. The appellant failed to transfer the land to the respondent. And so later, both parties signed a refund agreement requiring repayment with interest. The appellant paid only part of the money and later claimed that the agreement was signed under duress. And the issue in this particular case was whether the refund agreement was signed under economic duress. And the rule is that economic duress exists where you have a number of things. It exists where there is coercion, it exists where free will is removed, it exists where there is protest by the victim, it exists where there was no alternative option, it exists where steps were taken quickly to avoid the agreement or the contract, so that mere commercial pressure is not sufficient. It is not enough. The application of this particular case was that the appellants signed the agreement voluntarily. They did not protest at the time. They made part payment after signing. And that was an admission that actually the debt existed. And they did not even challenge the agreement immediately. And this showed that the agreement was entered freely. So the conclusion of this particular case was that the court held that there was no duress, so that the refund agreement was valid and enforceable, and the appeal was actually dismissed. Now, we have additional supporting principles in terms of cases which can actually deepen your understanding as far as duress is concerned. We have the case of Powell On versus Lau Yu Long, a 1980 case. And the rule from the case is that economic duress exists only if there is coercion of will that removes true consent, so that commercial pressure alone is insufficient. We have also another case of Lynch versus DPP of Northern Ireland, which is a 1975 case. And the rule from the case is that duress does not remove choice completely. Instead, it forces a person to choose between two serious evils. We also have the case of John Mburu versus Consolidated Bank of Kenya 2018. And the rule from the case is that to determine duress, courts consider a number of things. They consider whether the victim protested, they consider whether alternatives existed, they consider whether legal advice was available, and they also consider whether the victim acted quickly to cancel the contract. So that is all I have as far as duress is concerned. In our next legal lesson, we are going to talk about undue influence. If it is your first time here, make sure you follow this channel and you subscribe for more legal lessons.